Hello again. This is Rachel Rust from Wadler, Perches, Hundl, and Kerlick. If some of you listened to my video on uncontested divorce, you may be ready for the next step, which is, okay, how do I get there? How would I settle my case? And there are several different ways that you may reach that result. The first is what many lawyers refer to as a kitchen table approach. You don't really have to sit at a kitchen table, but you do have to make a list of your assets and your debts and agree who's going to get what and who's going to pay what. Likewise for your children, you have to discuss what your work schedule is, what will happen if one spouse who hasn't been working outside the home takes a job, what the kids' schedule is somebody going to stay in the prior marital home, and if so, how are we going to organize or reorganize ourselves into two separate households? If you and your spouse can agree on your property, then you can simply make a list and put a W and an H by each and say, okay, this is how we're going to divide it. If you have a schedule for the kids and how you want to share time with them, you can get out a calendar and color code it or make little marks on it that say this is how we're going to share our children and get them to their activities and try to disrupt their lives, try to cause the fewest disruptions to their lives as possible. If you can't talk to each other without fighting, maybe you can write notes. You can leave notes on a table or someplace else and say, here's what I propose, or here's what I think we own and we owe. What about you? And you can pass notes back to each other. That sounds kind of silly, but some people are able to communicate better in writing than they are face to face. If you can't do that, maybe you have a family friend that both of you trust, or a family member that both of you trust, or someone in church who will help you try to come up with these basic things. Here's what you got, here's what you owe, here's what your kids need to know about where they're going to live and how they're going to go back and forth. If you are able to get that done, then you can hire an attorney who will turn your kitchen table notes into a divorce decree. The same paperwork has to be done, but an attorney can draft that petition, a waiver, and the divorce decree. If you can't do any of that, then you can choose an attorney who you instruct to try to settle the case. Who you choose as an attorney makes a big difference in how your case is going to be resolved. If your attorney on their website advertises themselves as fights or aggressive, those are battle cries. Those are not settlement words. Those are words for people who are comfortable with litigating and they want to fight it out in a courtroom. If that's not what you want to do to settle your divorce, then you should pick somebody else. Mediation. That's another way to do this. Mediation is a process by which there is a neutral person who tries to help the parties resolve their case. In this area, oftentimes the mediators participate with the attorneys. So you go to a mediator's office with your attorney. You and your attorney are in one room. The other party and their attorney are in the other room. And the mediator will go back and forth. Can you do it without an attorney? Maybe. It depends on the mediator. The issue for mediators is usually that they can't give legal advice. And so someone at the end of it has to draft something in legal terms, and they prefer that a lawyer do that. And all mediators are not necessarily lawyers. Collaborative law is another way. That is a process by which an attorney who has been specially trained specifically is hired to settle the case. Both attorneys have to have been trained in collaborative law, and the key component for that process is that the attorney has to disqualify themselves if the case doesn't settle. So somebody else has to litigate the case. That's a whole different tape. We'll talk about that later. But all of these processes will result in a divorce decree that is entered by the court. The difference is who's doing the drafting. So back to the kitchen table approach, if you do it that way and you have a simple estate, you can probably do the fill in the blank form, the do-it-yourself forms that are available at texaslawhelp.com. If you have something more complicated or you're going to need deeds to be drafted, then you may want to take your agreement to an attorney so that they can transfer it into a legal document. If you go to mediation, you're going to end up with what people call an MSA, which stands for Mediated Settlement Agreement. The difference in that process is that a mediated settlement agreement is binding, whereas if somebody has agreed to something on the kitchen table and then you get ready to have it entered by the judge, if they change their mind, they can withdraw their agreement. They can pull it back. In a mediated settlement agreement, whatever you've agreed to, you're stuck with. And so that agreement, good or bad, that agreement will have to be translated into a decree of divorce in regular legal terms that the court understands and can enforce. That's it about settlement today. Join me the next time, or if you have any other questions, please give me a call at Wadler, Perches, Hundl, and Kerlick. See you later.